and follow the same guidelines that Ron Gibson has given everybody about establishing land patents. And that's what I would do.
First of all, I think it's really important that people understand it's only with the ownership of land that you have an inalienable right. Your warranty deed is not a title. A warranty deed will never be a title. That's why bringing that patent forward in your name is so important. The patent removes the warranty deed and establishes the true title. That's why it's called an allodial title. When that patent was issued to the first recipient, it's called the grantee, okay? And then in that document it says to their heirs and assigns forever. In other words, that land patent loses none of its rights, title, and interest in that given piece of land forever. So you buy the property 150 years later, you still can acquire the same rights that the original grantee had. That's what this process that I teach does. Now, you're not subject to land use regulation. Lawfully, you're not subject to property taxes, and you're not subject to court judgments because it's an allodial title. An allodial title means owing to no one, to nor lord nor superior. Therefore, the benefit, one of many of the benefits that you have by bringing the existing land patent forward, there is provision on the patent document itself. It is hereby granted to the undersigned, to their heirs, and assigns forever. And that forever is not up yet. I want to go back for a moment and give your listeners a little bit of a background. Our land right to land ownership is God-given. It's an inalienable right.
One of the things that I like to share with people, our Constitution is not a self-executing document. Did you hear what I said? Our Constitution is not a self-executing document. It lays out the restriction. That's why that constitutional book is small. It gives the government, by we the people, who are the bosses, we're the kings, very limited latitude in which they're to function, and they're to do it at your and I's direction. The disposal of land patent is conclusive evidence of the right, title, and interest in a particular tract of land, granted to a private party and from the United States government. In addition to the granting of the land to the grantee, that's what a person is recipient of that, because they grant and the recipient is a grantee, okay? The grantee, he also receives all of the authority and jurisdiction relating to that land. This is what is called a true title. Remember earlier in our discussion we talked about the fact of a warranty deed? That's no title at all. That's just a document showing that you have an equity interest in that land. The land comes to you from treaty law. A lot of people do not understand what that even means. In other words, when there's negotiations or agreement between nations, they're called treaties. And treaties are law of the land. And if you look at the Constitution under Article 6, Clause 2, it's called the Supremacy Clause. Okay? I want to read that to you. And I think you'll see where I'm going. This Constitution and the laws of the United States, which shall be made pursuant thereof, and all treaties made of which shall be made under the authority of the United States, shall be. Shall in law means that it's mandatory. May means that you can be discretionary about it. Will be the supreme law of the land, and the judges in every state shall be bound thereby, and the thing in the Constitution and the laws of any state to the contrary are notwithstanding. Now I want to ask the question, what does that tell you? I want you to think, folks. I'm not trying to put you on the spot. I'm not trying to embarrass you. I'm trying to get you to think. What does that tell you? Who is bound? The judge, isn't it? In what areas? Every state. And yet we have judges out there who are taking people's land by virtue of foreclosure, and we're going to get into that have no lawful authority to do any of that. A mortgage and your land are not one and the same. We're going to get into that in the memorandum of law. They are not one and the same. And the attorneys and the courts and the legislature have all just lumped them together. You miss a payment, we'll punish you, we'll take your land. Absolutely pathetic. And I'll tell you why. Because it's a violation of the Supremacy Clause, and it's a violation of the intent of Congress. And we're going to get into that. Congress intended for the poor man to get it's a grant, it's free. The poor man couldn't afford it. So Congress said, we're going to set it up to where these people are free and own their own land and do what they want to do to be productive. An old English law, when our forefathers came to this country, they came here with a burning desire to be free. Free of religion, freedom of speech, freedom to own the land, etc., etc. And they brought with them the concept of an allodial title. We call them patents, but they're allodial. Look at your tax bill. It'll be in your capital letter name. And that means that they consider you to be a subject. And I'm going to put it bluntly, a slave. We want to be free. And restoring your land right and your land position is the first step and the most critical one that you'll ever do to do that very thing. There's an old saying, unless you own property, then you are property. Okay? Most of you know that you've tried to build something on your land. You got all these rules and restrictions and obstacles, and they let you move forward as long as you pay. Folks, that's not freedom. That's embondagement. Because it is instituted by God and is reaffirmed in the Constitution under Article 4, Section 3, Clause 2, 432. And it's called the land disposal portion of the Constitution. And in that disposal, it is a authority, but it's also a directive to Congress to dispose of the lands to you and I, so that we can acquire that land and go be productive, raise our families, raise a garden, raise cattle, cut timber, whatever the issue is. And I want to say something here, and I want you to listen carefully. All wealth comes from the ground.
Amen.
The land patent is issued by the United States government to the grantee, and the land patent stands forever. I want to repeat that. Your land patent stands forever. That's why on every patent, every single one of them, it says it's hereby granted, and it gives a name to their heirs and assigns forever. Had a very lengthy discussion with an attorney in Florida the other day on behalf of a client of hers. And I've been called on many occasions to be an expert witness in court cases having to do with land patents and property rights and right-of-ways and water rights and whatever. And she kept coming up with this administrator. The guy's done his land patent, by the way. And he has a mortgage, and he struggled. And she's trying to defend him. And I said, you're doing the wrong defense. She said, what do you mean? And I said, you're trying to make a constitutional argument in an administrative court. And I said, they're not allowed. She said, what do you mean? I said, the patent comes with authority and jurisdiction. And that authority and jurisdiction stand forever, and its authority comes from treaty law. That treaty doesn't come from administrative jurisdiction. Okay? And so we finally got her to see the difference. 2.5 hours trying to explain it. And I've had a lot of trouble, and I want to say this respectfully, but with a lot of attorneys and judges. The attitude in a lot of them, not all, there's some dang good attorneys out there. And I'm not here to throw stones at attorneys. But a number of them that I have met try to portray that they're smarter than you and I are. And I don't know it all. I don't claim to know it all. But I'll tell you what, I study, and I have been in many, many, many debates having to do with land patents. And I can hold my own. This attorney made the comment, well, how do I know that what you're telling me is right, that it doesn't fall under an administrative jurisdiction? I said, very simple. I should show me where the forever clause and authority in a land patent was ever removed. Got stone quiet on the other end of the phone. Now, I wasn't trying to throw stones at her. Pretty sharp gal, really. She then began to see. And that's what I hope I help you folks do, to see the power and the authority and the jurisdiction of a land patent.